The doctor that you have sued in your medical malpractice case is now being cross-examined, using his own words, his own pretrial testimony. And now when the case goes to the jury for a decision, now the jury wants to know, can they read all of the doctor's pretrial testimony in order to determine whether or not the doctor was inconsistent and was lying about something that he said earlier compared to what he said at trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is no. The judge is not going to allow the jury to see and read all of the doctor's pretrial testimony. Yes, during the course of cross-examination, I have an opportunity to go ahead and use the doctor's pretrial testimony and the transcript. That is, all of the questions and all the answers that he gave years earlier during the pretrial litigation process. Now, if he has said something different, I can use that prior testimony to show to the jury that there are inconsistencies. And then later on during closing arguments, I can argue to the jury that the doctor is inconsistent. And as a result of those inconsistencies, that he's actually lying. And now you should not believe what he had to say. So I can do that using his pretrial testimony. But now there may be an instance when the case goes to the jury for deliberations, to reach a verdict, to decide who is more likely right than wrong. The jury might turn around and say, you know what? We would like to see the entire transcript of all the questions and all the answers the doctor gave. Can the jury see that? The answer is no, because that transcript, that testimony that he had given years earlier during the pretrial litigation process, that was not admitted into evidence during the course of trial. Instead, the doctor testified, he explained what went on, and then I used his prior testimony to show that what he said years earlier is inconsistent with what he said now at trial. That I can do. The judge is only going to allow testimony that is admissible, and the jury is only supposed to base their verdict upon the testimony that was admitted in evidence during the course of the trial. The judge will likely turn around and tell them, ladies and gentlemen, that prior testimony was never admitted into evidence, and there's no reason to, since that information was obtained during the course of trial. And anything that was inconsistent, the attorneys are then going to use during cross-examination to try and get to the truth of the matter. So why do I share this great information with you? I share it with you just to give you an insight and a behind-the-scenes look at what goes on during the course of a trial involving a doctor who's being sued for violating the basic standards of medical care here in the state of New York. You know, I realize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Jerry Oginski. Have a great day.